Allow me to welcome you to today's event. Mark, I can see you. Hi, how are you doing? All right. By way of introduction, my name is Evelyn Kimani. I'm the acting CEO of the Chartered Institute of Arbitrators Kenya branch, and we're very, very privileged to be joined by our sister, or at least professionals from our sister branch or HQ in London, who will be taking us through today's event. And as you're aware, we are looking at the use of AI and arbitration. This is part of our webinar series, in which case the Chartered Institute of Arbitrators Kenya branch use this platform to disseminate critical information to members as well as the various stakeholders that we have. And today we'll be looking at the topic of integrating AI in arbitration, practical strategies for responsible and efficient dispute resolution. We've all had cases where the use of AI has led to some critical complications in the arbitration process. So what happened is that last year, HQ published its guidelines on the use of AI, and we are privileged to have two people who are part of the team that came up with those guidelines to take us through what it is that they envision for those guidelines, and most importantly, how we can effectively and safely use AI in arbitration. So mine is very, very short. It is to welcome you in this webinar and also welcome our moderator, who will then take us through the introduction of the panelists that we have today, and then he can take us through what they have prepared for us. Our moderator for today is Mark Oroko. He's dual qualified. Like most people at the Institute, he's both an engineer and an advocate, recently admitted to the Kenya Bar. He holds a diploma from the Kenya School of Law, and he's a member of the Chartered Institute of Arbitrators. And not only is he a member, but he also serves in the Young Members Group Steering Committee, both within the Chartered Institute of Arbitrators as well as within the IEK, that is the Institution of Engineers of Kenya. So he brings in dynamic and multifaceted credentials, both within the construction sector as well as in law and dispute resolution. He's passionate as an advocate, and especially in climate justice, community rights, tech issues, and so on and so forth. So thank you very much, Mark, for taking us through this and even accepting to moderate these sessions. I know you have a lot in store for us, so I'll not take much more of your time. And before maybe I can introduce Mark, we have Prof, our chairman, the Chartered Institute of Arbitrators Kenya branch chair, Professor Kenneth Wayne Mutuma. Chairman, I don't know whether you're in a position to just say hi.
Yes, I am indeed. Thank you very much. It's such a pleasure. Thank you, as always, CEO, for putting all of this together. We acknowledge the valuable work that you do, you and the Secretariat. I also like to thank Mark for being a very able moderator before we move into the actual session, and our distinguished guests, Siobhan and Annabelle. It's such a pleasure to have you with us, speaking on a topic of immense interest. So as a body and let's say the dispute resolution sphere, we are affected by matters AI, like every other of our colleagues, the governance space, the environmental space, the legal practitioner space, and so forth. And the discussions have a two-pronged side to it that I'm so looking forward to hearing the panel speak about. First, of course, is how you leverage all of this. I think increasingly, technology has always had the face of efficiency, so it does change the dynamic and the rules of play in many ways. And you can see that from many of the facets of the work that arbitrators will be undertaking, and the other players in the dispute resolution ecosystem, including how to sort out documents, to categorize those documents, and some of course, have knowledge to slowly start on the function that has to do with the most vital role of a tribunal. That's the question of making a decision. Now, that's one side. The other problem, of course, is how do you guard against the dangers that this presents? So there are different dangers. I think we'll be very interested in hearing the panel speak about. Well, first, of course, there's a danger of redundancy. What exactly are the different players now expected to do? So we've sort of introduced the calculator, if I may use that very simplistic analogy, in the exam room. And so what does that mean now for our times tables and all of that? A lot of work on the lower end of the ecosystem was being done by younger practitioners. Some of it will be done by tribunals. What is AI going to mean? And then there is the question of trust, because parties contract to get a tribunal to do a certain function, and it's like in many other areas, there's some kind of fiduciary relationship between that function and what the parties expect. So, what are the dangers when we move into this space? We have seen, of course, all kinds of problems, mainly around disclosure and how much is actually revealed to parties, whether there is a duty. It gets very, very technical and even more interesting when you ask whether you should reveal if you got the right answer all the same. I mean, it's one thing when you're dealing with hallucinations. My apologies for the background noise. Okay, so my apologies for that. I'll just try and speak louder than the announcement. Um, I would, of course, want to hear from the panelists. Siobhan and Annabelle and Mark, I can tell you I love very quiet airports because you don't get that. I really like the large airports where you're expected to know where you should be at what time. But I'm keen on the last end where, of course, you get the answer right. There's no hallucination. And what that actually means when it comes to disclosure, trust, and those aspects. And then, of course, there's a lot of discussions around the black box and what's happening to information and ethics. We have a wonderful panel. Like you had, our moderator is multidisciplinary, multifaceted. He'll also be able to sort of shed light. An engineer sort of goes behind the engine of these things and tells us some things that we wouldn't in natural order be aware of. And then, of course, we've got wonderful panelists in the form of Asioban and Annabelle. You can be sure that we're really looking forward to hearing from you. So, welcome, members. Thank you for joining us. Thank you very much, CEO. And it's my pleasure to welcome the moderator, someone that I know with personally and have great respect for the kind of work that he does. And please, Mark, feel free to take us on. Thank you.
Asante sana, Prof, and safe skies when you travel. Thank you so much, Madam CEO, for that kind introduction, and good afternoon, everyone. And very much welcome to this Charter Institute of Arbitrators Kenya Branch ADR Talk Series webinar. My name, as you've been told, is Mark Oroko, and I'm delighted to be your moderator for today's discussion. So we are gathering at quite a fascinating and critical juncture for our profession, and the conversation around artificial intelligence has moved from the abstract, what if, to the very practical, how do we use it and how do we manage it? This has been highlighted by Professor Mutuma in his keynote address. So for arbitrators, counsel, and the use of arbitration, this presents quite an immense opportunity and significant challenges in equal measure. So our focus today is on the practical, and we are not here just to theorize about AI, but to explore the tangible strategies for integrating it responsibly and efficiently into our arbitration practice. And to guide us through this complex landscape and discussion, I have the pleasure of being joined by two exceptional practitioners. One is Siobhan Abraham, and I will briefly introduce her profile. That Siobhan Abraham is a senior associate, and that's a global stroke European perspective and a top tier that is in practice cross-border commercial and treaty arbitration, both in ad hoc proceedings and under a range of arbitration rules, that is including the LCIA, ICC, exceed cases, and she advises clients across a broad range of sectors, with recent highlights including cases in technology, fashion and licensing, gambling, and real estate sectors. Siobhan advises clients across multiple jurisdictions and has acted in disputes applying a variety of governing laws, including the laws of Mexico, Romania, Cyprus, and Malta, as well as multiple disputes under English and international law. She's also experienced in arbitration-related commercial litigation in the English High Court and is a qualified solicitor advocate who undertakes her own advocacy and regularly sits as second chair. Earlier in her career, she was seconded to LCIA Secretariat Casework team as counsel. Welcome, Siobhan.
Thank you, Mark, for that kind introduction.
Thank you. Our other panelist is Annabelle Kingston. Annabelle, you'll forgive me, I'm not sure about how the other name is pronounced. You'll help me with that. Welcome. And Annabelle is a seasoned arbitration professional, that is both international and in African disputes, procedural and substantive expertise. Annabelle is a dual qualified barrister and solicitor in Nigeria and England. She holds an LLB from Ibenedion University in Nigeria, a BL from the Nigerian Law School, an LLM degree from the University of Bedfordshire Business School, and an MBA from the University of Suffolk. Currently, she's on the verge of completing a PhD in law from the Oxford Brookes University. She's currently a law lecturer at Regent College London. Her research and teaching interests include investment treaty arbitration, international commercial litigation, human rights, international commercial arbitration, and artificial intelligence in international arbitration. Much of our work concerns the practicality of using AI-based tools in international arbitration, the role of AI in international arbitration, and more recently, the Africanization of investor-state dispute settlement mechanism. She's motivated by the pursuit of justice, fairness, and technological innovation in the legal field. And to Siobhan and Annabelle, thank you so much for making time to be here. And before we dive in, a quick note on how the session will run. I'll be posing the questions to our panelists, and we encourage you, the audience, to participate. Please use the Q&A feature to submit your questions, and we'll address as many as we can in the latter part of the session. We also have the newly published CIAB AI Guidelines 2025 as a key reference point, which had been earlier on highlighted by Madam CEO Evelyn Kimani. So let's begin. And to get us started, it's helpful to understand where we currently stand. The conversation has evolved so quickly. And Siobhan, From your vantage point in London, observing the global trends and client interactions, how will you describe the current state of play of AI adoption in international arbitration? Are we seeing widespread use, or is it still a tool for few early adopters?
Thanks,
Your
Mark.
thoughts?
I think there's two parts to that question, really. So there's the question from the perspective of a law firm in London, and then there's the client perspective from a more kind of global point of view. And I think in the first part of that question, we are really seeing AI usage as almost unavoidable now. It's integrated into almost every aspect of practitioners' work lives and personal lives to varying degrees of sophistication. Certainly, in my view, I think this is really a tide that's turned quite recently. Released in 2022, and there have been some real step changes in the last year or so, I think, with the quality of AI tools in the legal world. So this is still early adoption from a law firm perspective because there's so many compliance and regulatory points that law firms are looking to comply with. But equally, it is integrated into what we do. And we're certainly seeing from clients that they are pushing practitioners to streamline the work that we do by using AI tools, but also on a sort of cost basis. So certainly I think that law firms are reacting to that push from a client perspective, but also from their own cost perspective. It's getting to a point where it is much more efficient to be using these integrated tools. I'd be very interested to hear Annabelle's thoughts on the point from an African point of view, but I do think that from my perspective in London, there's a bit of a range of uptake from clients. Certainly some of my East Asian clients have been a bit more reluctant, I think, with the use of AI in the work that we do. But European and UK-based clients have certainly been pushing for AI to be used.
Yes, thank you. Thank you so much for that perspective, Siobhan. And Annabelle, building on that, do you see a different picture when you look at the African arbitration landscape? And are there maybe specific drivers or perhaps barriers to such adoption that are more pronounced in this region? And is maybe what are your thoughts on it?
Thank you so much, Mark. Thank you for the very kind introduction, and also thank you for the question. And I think also just basically drawing from what my colleague, Ms. Abraham, have said, AI is something that is it has become very rampant. I'm more in the academic field, and you see students, they cannot submit an assessment, for example, without using AI. You ask them questions and it's immediately ChatGPT, so it's something that has been sort of interwoven in every part of our life. I think particularly in Africa, it's not as widely used in so many law firms in Africa. And it's not just because, they don't really know how to do it, but I think the major problem is accessibility of these resources, of certain AI tools. Primarily, when my colleagues and I drafted this timeline, we wanted to create something that was timeless, something that was current, something that could cut across different jurisdictions globally and not just in Europe. So we identified some benefits that, if you're using AI in international arbitration, these are the things you would achieve, or these are the things that would benefit your firm. And we also looked at some of the risks. So I don't know if you want me to sort of buttress on a little bit of the benefits and the risks, or is there going to be a question on that?
Yes, we will get to that, but you can surely shed some light on it as we proceed.
Okay, excellent. Perhaps I'll just let you moderate and ask questions on that. So I don't want to talk more when there are other questions that would be asked. But yeah, over to you.
Thank you. Thank you so much, Annabelle. And thank you both. That quite gives us a great foundation. Now we can get into the practical strategies as we had indicated in our title. We know that AI tools are being used for document review, legal research, drafting, and even data analysis. But how are the best practitioners doing this? Annabelle, if you are advising a tribunal or council on how to responsibly use AI, and that brings us to the points you wanted to highlight regarding the merits and demerits for this. So if you're advising a tribunal on how to use AI responsibly for a complex document heavy arbitration seated in probably an African jurisdiction, what will be your top 3 pieces of practical advice?
Thank you again for the question. I think there has to be perhaps a threshold assessment when using AI. There are things that, of course, you can use AI for, and it has to be proportionate to the nature of disputes. So, for example, and perhaps Ms. Abraham would agree with me, um, it depends on the disputes. Perhaps the value and complexity of the case would justify using AI. In the guideline, we talked about high AI risk, and we talked about things that you need to disclose when using AI. Okay, so when there's a difference between generative AI and just AI perhaps used for legal research, when you're using AI for just legal research, nothing generative, there is really no reason to disclose that. But if you're using it to draft pleadings, generate pleadings, for example, or other sort of high level uses, then you should disclose that. But moving on to the advantages of AI use, I just have a few that I would like to sort of highlight. And additionally, there are a lot of risks as well that I also wanted to point out. So one of the major benefits of using AI is efficiency and case management. Okay, so for a generative AI model, you can draft pleadings, although you need to disclose this if you're using AI for that. You have voice recognition AI that could listen to witness interviews. It can generate transcripts for you, can summarize them, and perhaps even assist you in preparing defense statements. So some of these tools are very important. So imagine, being a counsel representing Kenya, in, I don't know, an investor state dispute settlement against Germany, a German investor. They're claiming $2 billion in damages. Um, you have hundreds of thousands of documents. You've got multilingual contracts. You've got encrypted emails, and so forth and so forth. Now, if you were to do this the traditional way, as most African law firms would do, this would take, a lot of time. Okay, it might take months and a lot of human, resources, and it would cost so much as well. But if you have the right AI tools, you can do this in a significantly cuts the time, the money, the people that you need. So it's very efficient in that respect. But it's important to also highlight some of the major issues that should be on our watch list when using AI. And one of those particularly is AI has hallucinations, I beg your pardon, and deep fakes. And Professor Kenneth talked about this very briefly, which I wanted to highlight. In 2025, for example, there were two New York lawyers. You can look this up. Two New York lawyers who submitted a court brief containing fake case authorities. Now, what they had done was they prepared their brief really late at night. They had asked ChatGPT, could you tell me some cases, that would be relevant in this situation? They did all that, uploaded the file, but it turned out that some of those cases were fake. They never existed. So ChatGPT or any other AI tool can generate fabricated cases. Um, so there is a need to have human oversight. You shouldn't just depend on the machine like that. You should really look at it. Okay. I think one might also ask, why does this happen? Because AI is supposed to be intelligent. Why are they hallucinations? Why are they deep fakes? But particularly in international arbitration, the problem we found is that the doctrine of confidentiality is a big one, right? We know that AI works on a garbage in, garbage out process. It only works on information that has been submitted to the algorithm. So with arbitration, for example, we don't really have so much data, or most of the data, are not publicly available. So there is basically a gap between what is actually there and what should be there. Okay. Additionally, many AI systems are trained on cases from Europe and North America. That would cause a lot of issues, for example, in the African perspective, because they don't really know cases in Africa or in certain jurisdictions in Africa. So it's very important that when we're trying to use AI, we should make sure that we're using it as an assistive tool rather than a decision-making tool. We should make sure that these algorithms are trained in our data, in our cases, as opposed to just buying something from Europe or using something from Europe that doesn't quite reflect our needs. Lastly, I just wanted to talk about data security, cybercrime. Cybersecurity is a big one. We've been plagued. Unfortunately, the rise of AI has led to a plague in cybersecurity issues. So perhaps to protect us, to protect firms, we have to make sure that, we know sort of the data used, we know the information used. We shouldn't upload sensitive state-related information to AI platforms if we're not sure of it. We have to also make sure that we're vetting the AI providers as well for privacy and cybersecurity safeguards. Just one thing, the last thing I wanted to mention was one of the cases that happened with Samsung. Again, this can be looked up. Employees had uploaded confidential information in there, and then somebody else just used ChatGPT to ask a question about, the Samsung, and then got all the information, the confidential information. So it's important that we make sure that we're vetting these tools and making sure that our information cannot be reused by someone elsewhere.
Yes, thank you so much, Annabelle, for technically brushing through the entire document. That is so kind. And I'm sure our audience is taking note. And if there are questions, Madam CEO, maybe you could help me highlight those. Now, Sihobam, just a follow-up on this regarding the hallucinations and black box discussions. The CHAP guidelines emphasize on transparency and accountability. And from a law firm's perspective, how do you operationalize this? And for instance, if an associate, let's say in the example where Annabelle just indicated, where information regarding Samsung or maybe any other users is fed into the generative AI, what are the internal protocols in your firm or best practices that should be put in place regarding disclosure of these particular pieces of information, that is to the tribunal and even to the other opposing counsel? How do you manage the risk of these hallucinations, internal mechanisms, and especially from a law firm's perspective? Over to you, Siobhan.
Thank you, Mark. I think the headline answer to your question is that certainly in my firms in London and internationally, it's been very, very careful about the kinds of tools that are licensed for use in law firms. So, for example, my firm only licenses a particular number of tools. We're on trials for various other ones, but ChatGPT is not licensed for use. So we're not allowed to use OpenAI for professional purposes. So instead, for the kind of general T4, we're allowed to use Copilot, but it's a very specific personalized iteration or license of Copilot, which is a closed learning model. So it will only use the data that is within the framework of the closed model. So it won't have access to the broader internet. So I think the other ones that we've been licensed to use are Westlaw Deep Research for research tasks, and then Legora. which is the one that the firm has just agreed to use, and that's more of a kind of case analytical tool. But again, it's a closed learning system, because the confidentiality point is really the most important point there from a kind of law firm perspective. But I think building on that, the protocols that the firm has been putting in place, again, have been really particular. So there's been, you're only allowed to use particular tools for particular tasks, rather than being able to use a wider tool for kind of any aspect where you might think that AI is useful. So again, like I was saying, Westlaw for research and Legora for case analysis and document management, so chronologies and things like that, which I think is where a lot of the use will be in the arbitration context. But we've been asked to do mandatory AI risk training before we even have access to any of these tools, and tool-specific training sessions, which are being rolled out regularly. Then I think the big point from a law firm perspective is that I think because AI tools often replace kind of mechanistic tasks that junior associates and trainees in our teams are traditionally doing, there is a verification point. So the firms have been extremely careful to ensure that any output that you get from a generative or other AI tool is very carefully verified for its source material and for the contents of that drafting. I think it's quite interesting. I'd be interested in your perspective and whether Annabelle has seen this in any active cases, but I don't think yet I've seen any generative AI drafting in pleadings in being used, in real time in the real world in an arbitration. Certainly seen it for other aspects where AI can be helpful. So translation is a big one. We've seen a lot of generative AI translations of varying degrees of quality, and in document production. And for things like transcription, I haven't seen it yet for stenographers in a hearing, but I think that will be coming. But no, nothing yet in kind of generative AI for actual drafting, which I'm sure will be about to change. But it's more behind the scenes at the moment.
Mm-hmm. Interesting, and quite informative discussion there. Thank you, Siobhan. Now, Annabelle, having been a member of the team that drafted the CHAB 2025 guidelines, and this is one of the most practical contributions of the new guidelines, where in Appendix A and B, the template agreements and procedural order. Annabelle, as a drafter of the guideline, could you please just take us through? I know you had mentioned a few items on confidentiality, and could you please take us through a few other clauses for a tribunal at a first case management conference? Let's say, for instance, sitting in Nairobi. What are the essential questions that they should ask the parties, to populate a short form or a long form procedural order on AI?
Okay, thank you so much for that question. Just to sort of comment on what Ms. Abraham have said or asked, she mentioned that AI typically is used for basically like administrative tasks, research and all of that. But she asked whether it has been used to draft pleadings. The correct answer is, I mean, I don't know if this is the correct answer, but at least what I know at the moment is in arbitration, we haven't really seen, or at the time we did when we drafted the guideline, we hadn't really seen anyone in arbitration particularly, but there've been a couple of cases, at least in the US, during litigation where lawyers or attorneys have used AI to draft pleadings. So it hasn't perhaps reached the door of international arbitration, but it might get there soon. So yeah, that's just basically like a short answer to the question. Okay, so moving on to the question you asked me, Mark, about sort of like practical contributions and Appendix A and B, if I'm correct.
Yeah,
So when we drafted this, we wanted a situation where party autonomy was first. Okay, so parties could decide to use AI, but they had to disclose this when it had to do with high AI use. And then we drafted sort of like an agreement, two agreements actually, or contracts, as it were, in Appendix A and B, where practitioners could sort of adopt this in their practice. In Appendix A is basically a template between the parties to decide whether or not they want to use AI and also to disclose what sort of AI tools that they're going to be using. Appendix B has to do with a procedural order. So this is where the tribunal can issue, rulings based on what parties have decided. So to just talk you through what is contained in these appendices, the first would be that when parties intend to use AI tools, they should disclose typically what they need this for and the purpose. So if you're going to be using it for legal research, document review, whatever, you need to be able to sort of disclose this. So we need to talk about the permitted AI tools and the permitted uses. Now, a question I've usually gotten based on Appendix A is, what if we don't disclose, or what if we disclose, but then we use something else? What happens? How can you tell if we've used something else? Now, the tribunals on Appendix A have been given the authority to investigate if there's any suspected, AI tool that wasn't disclosed. So they have the right to do that. And they can also do that. They have sort of very vast powers. They can appoint AI experts who can inquire, seek information and clarifications on whether a certain AI tool was used. So this hopefully answers that question. Tribunal should also try to limit AI uses. Arbitrators are also allowed to use AI, but they also need to declare this as well and tell parties this is what we're using AI for. It shouldn't be used to draft awards, but it should basically help them to perhaps summarize facts of the case or whatever it is, but not at all to draft awards. The appendices also talk about confidentiality and data protection. We would have to find out, what licenses do you have to use this certain AI to? Have you vetted these tools? Who are the AI providers and all of that? What sort of information do you want to put into this AI? So like I said, it's mostly about disclosure obligations. And also we're very keen on data protection.
Yes, thank you so much, Annabelle, for that kind of highlights about the guidelines on appendices A and B. And coming to you, Siobhan, what do you think about these guidelines? Do you see these as setting a global benchmark? Because in most of the instances, as we are aware, the law will always follow innovations. Like sometimes we have quite disruptive inventions and innovations around technology. So do you see these guidelines as setting a global benchmark? And looking forward, are there areas you believe will require further rulemaking or even guidance from institutions like the Chartered List of Arbitrators? For example, as mentioned by Annabelle, there are issues around data security, confidentiality when using these cloud-based AI tools, and you also spoke to those. So which are these? What do you think? Are there areas you believe will require further rulemaking?
I think it's very difficult to say at this stage. I think that AI tools are improving on a log scale rather than a linear scale at the moment. So it's very difficult to predict what the shape and the power, the computing power of those tools will be, really even on a 1-year timeline, let alone a sort of 5-year timeline. So I do think there is likely to be more regulation in the space. I can speak slightly to the high risk AI point that Annabelle mentioned in a second, but I did just want to note that I think the Appendix A in the CR guidelines is a really interesting document, because I think correct me if I'm wrong, but I think it is designed either to be incorporated into an arbitration agreement at the outset of a contractual relationship, or as a standalone agreement between the parties to regulate AI use. And I'd be really interested to see how that is taken up by parties, because I think with the way that AI is going, it's becoming so normalized into the way that we conduct our work, and that we even conduct our personal lives. Certainly in the UK, the US, and Europe, that I would be quite surprised if parties were agreeing to limit the way that they use AI in a dispute context at the outset of the dispute. I think it's very important to incorporate something like the CRB guidelines, or some of the other guidelines that other institutions have been preparing, into a procedural order at the outset of an arbitration. But I just think it's changing so fast that it's very difficult to anticipate where the differences will be. I think we will be seeing more in the way of disputes about the use of AI as we go through arbitrations, as they proceed, and as time goes on. Certainly, I've seen disputes in live arbitrations about the use of AI in document production and translation, but not really from a point of view of parties having tried to regulate how they use that AI intentionally at the start of the arbitration. So I think that will be important to incorporate, and the CRB guidelines are really useful on that.
Thank you so much, Siobhan, and I appreciate. I will wish to pick your thoughts on the same. Annabelle, do you think, what will you advise a highly practitioner in the area of arbitration to prepare on for this? What kind of skills would you wish that a practitioner develops right now to remain relevant and excel in an AI, enhanced field?
Thank you for that, Mark. I think there has been a misconception that for you to use AI, at least certainly in the African context, you have to know how to code, you have to be very vastly smart or very into technology, but that's really not the case. I think we should really concentrate on having the legal skills, having knowledge and understanding of arbitration, just as a legal framework, and also just being vastly aware of, the AI tools that we have. I don't know how to code. I don't know if Miss Abraham does. I mean, perhaps she does, but the point is that, we don't really have to be overly tech savvy to be able to use AI. AI is something that is literally at our doorstep. It's very easy to use. Once we have the right tools, once we have the right, AI tools, anybody can use it.
Yes, thank you. Thank you so much for that. And I hope, Madam CEO, you or your team is helping me to highlight any questions in case they are from the Q&A. But in the meantime,
Mark, that's okay. What maybe I can highlight is that in case you have any questions as we go along, feel free to put it in the chat, and then we can have some of those questions either addressed during plenary, or we can have them answered as we go along, depending on the question and where we are with the presentation.
Absolutely. Thank you. And to our panelists, what do you think are the biggest drafting pitfalls that you see currently? And now looking at advising tribunals and even practitioners, is there a danger of being too prescriptive about which AI tools can be used, given how fast the technology evolves? I remember Siobhan indicated that the use of OpenAI and ChatGPT is prescribed. Is it in the UK and EU? So what do you think are the biggest drafting pitfalls that you see currently? And do you find them too prescriptive about the use of these AI tools? Yes, Siobhan, go first.
I'll go ahead on that one. I think this links into something that Annabelle just said about the importance of remaining really up to date and really sort of maintaining your legal skills when using AI. I think it's a really interesting crunch point that we're seeing, particularly with junior associates and trainees, because the AI is actually really good now. The research that it produces or the drafting that it produces when you're using generative AI is pretty high quality. And I think there's a real risk that mid-level associates, sort of junior practitioners, are actually just using the AI to replace tasks that trainees or interns would traditionally have done. And I mean, we can see it happening in real time. Juniors and trainees are really not developing those skills. And that's not through want of trying or any fault of their own, but they just aren't getting the opportunities to do the kind of sort of investigative and thinking work that they would traditionally have done. So, for example, on a kind of practical level, things like document summaries, call notes, sort of reviews, research reviews even, are just being done by the AI and not by the trainee themselves. And then it passes up the chain in the usual way, and senior associates, partners are looking to verify the work that the juniors are producing. And I think it will be quite a challenge that we're all going to have to look into about how to effectively train our junior lawyers when there is this much cheaper, much quicker, much more efficient tool that's producing work that often is better than what you would receive from a junior trainee. So I think that is going to be a real challenge for the general practice of arbitration. And just to link it back to the question that you've asked about pitfalls in drafting, I think, you know, as we move through the use of these tools, there will be gaps in what generative AI drafts with the assistance of lawyers as people get more senior. I think from a very practical point of view at the moment, as Annabelle mentioned, the generative AI is only as good as what you put in. So if you're uploading the documents from the case or something, and then it's producing an answer, it will only be as good as the prompt that you give it. So I think there's a lot of learning for people to do about how to make those prompts as effective as possible, the guardrails to give the AI and the information that it's given to produce what it can. I also think that people expect an AI, generative AI, to produce a really long, really good first draft, and it doesn't work like that. It works in chunks, smaller kind of building blocks as you produce your AI. So, you know, you might receive a sort of 10-page draft, and pages 8 and 9 will just be completely wrong.
Well, thank you for that. Thank you for that, Siobhan. And what are your thoughts on that, Annabelle?
Yeah, I completely agree with Surban. It is again, just not talking from the practitioner's perspective as Surban has, but just in the legal field and in the academic field, you know, I have seen students who do not put in the efforts whatsoever. You know, you ask them questions, it's like they've forgotten how to think. So as soon as you ask a question, you give them a coursework, the next thing is they put it on one of these generative AI tools. But one thing that I continually hint is AI is not bad. The use of AI is actually really, really good, but you have to have a human look over the documents. So if you're given a certain task or whatever brief to look at or legal summaries, it's fine to use AI tools if they're licensed and all of that to help you get the work done quicker and easier. But you also need to have that human influence. You really need to go back and look at the document and find out if there are gaps. We talked about hallucination earlier on. There are going to be, gaps and sort of issues, deep fakes in the documents AI has provided. Not always, but sometimes that is the case. But if you do not go over the document, if you do not go over what AI has produced, then it's going to be disastrous to say the least.
Just to jump in there, I do think quite often you'll see an AI and it will be wrong in quite convincing way. It's a very confident drafter. So if you're not very familiar with the concepts that you've asked it to look at, it's very easy to miss. And if you don't spend the time verifying it, you know, you're putting this stuff out into the world and it is wrong, but not kind of at first glance. I think that's quite a worry.
Thank you so much. And that highlights some of the problems arising out of the use of AI, both as a challenge and an opportunity. Thank you so much. Now, on to what the regional, realities and the way forward for, practitioners in this particular area. And back to you, Annabelle. Zooming back to our, Kenyan and African context. What are some of the low-hanging fruits for AI adoption here? Looking at a solo practitioner in Nairobi or a young arbitrator building their practice back at home in Nigeria. What are some of the most accessible, and low-hanging fruits and impactful AI tools or applications that you would recommend today?
That's a very important question. I think basically the problem that we have so much, or the problem I have seen in Nigeria, for example, is accessibility. So many small and medium-sized law firms cannot access some of these really high-end, expensive tools. So I think, again, what we need to take into consideration is what do we actually need this AI tool for? And then if we can break down some of those sort of main areas, then we can determine what sort of AI tools can be accessible, what sort of AI tools that we can afford. ChatGPT is basically like a no-show for the main works, but I would advise using ChatGPT for perhaps just sort of like legal research. If you need to perhaps find cases or something, ChatGPT can be used just for the basic administrative task that could be used, but for the main arbitration work, for the drafting, and some of the high risk issues, ChatGPT should never be used. Um, Again, not to advertise any AI tool, but then we have
Mhm.
Harvey AI, which is used by many law firms, at least I believe in London. And they're used for legal research as well, and drafting and contract analysis that can be used. You have Copilot, Microsoft Copilots that can also be used. You've got Google Translate, especially if there's a multilingual agreements or documents. Google Translate can be used. I mean, there's so many. You've got Paxton AI, you've got Everlaw, you've got Blue J Legal. There's a lot of them that can be used. The problem is how, for example, with Harvey AI, how accessible is it? Like, does it have so many information about, African cases? Because it's widely used in the UK, it's widely used in the US. So the problem would be integrating or incorporating data from Africa, from, our own regional perspective.
Thank you. Thank you so much, Annabelle. And I appreciate that perspective. Thank you for that disclaimer as well that you are not advertising any AI tools, but for purposes of our members appreciating the available AI tools that can be used for these purposes, we really appreciate mentioning, and without prejudice to the rest that you didn't mention. And back to you, Sioban. What are your thoughts around the low hanging, AI tools, and specifically looking at the kind of efficiency which I know you had spoken to and the quality of work? You've indicated very clearly that the kind of prompts that are put into the AI tool will will determine what kind of result you get. And while at it, to what extent now, having gotten the AI generated product, to what extent will you apply now your original intelligence outside that artificial intelligence while ensuring the quality of the work without having to break a bank at least?
Yeah, I think it's really important that we do retain sort of your human intelligence whilst utilizing the AI intelligence that's available to you. From a kind of practical perspective, the ways I've found AI most useful are for things like very quick document summaries. So, for example, say that you're on a business development call and you've been put in touch with a potential client. They've sent you some documents and you're not being paid yet or anything like that. So you want to do a kind of quick review. I think things like Microsoft Copilot and to an extent ChatGPT as well could be really helpful for that. My firm prohibits the use of ChatGPT, so we use Copilot for that kind of work. But just to get a quick idea of this volume of documents that you've received, is a really useful use of AI. And the same goes for things like translations, as has been mentioned. I think it's really leveling the playing field when you're receiving a large volume of documents in a language that you don't speak. And it will be really interesting to see how that filters through full arbitrations. But again, practically, I think it's most useful for digesting large volumes of information into sort of accessible bite-sized pieces quickly. And that's something that can be done by senior practitioners, by junior practitioners, and then we need to apply our own human understanding on top of that. And I think where we will, the sort of important place that human understanding will come in is in the client relationships that we have and the sort of personal relationships and the conversations that we have with our clients and with witnesses that we have in cases. I don't think AI is going to replace that quite yet, but maybe.
Thank you so much. And that speaks to now the use of the original intelligence, the human being, and the human feel of the drafting of documents or references before a arbitral tribunal. And then that Siobhan indicates clearly that AI is not going to replace the humans in this. And at this point, I'm not able to see the chart, but I want to believe if there could be any questions, then Madam CEO, the Secretariat could help me highlight them. But as we gear towards the questions and an engaging session with the audience, I'd want our panelists, to maybe give us your thoughts on what are some of the fundamentals of reasoning and advocacy, especially in the application of arbitration, both from your perspectives as practitioners and academia. What do you think? What are your thoughts around this and the current state of ADR? Yes, you'll go first, Annabelle.
Sorry, I didn't get that. Could you repeat the question, please?
What are your thoughts generally around the practice of ADR, your perspectives on the practice itself, and even from an academic lens? What are the prospects of this practice, both regionally, nationally, and even globally?
I mean, I think the practice of AI is the practice of arbitration, I beg your pardon, is something that is cross-border. It's complex, and I think it's something that's, like I said earlier, AI is not going to replace. And again, like Simon has said, it's not going to exercise, judgment. It cannot really have that human feeling in interpreting complex commercial relationship or talking to witnesses or even speaking to the tribunal. It's not going to do that. It's something that we need to build on our own. We need to be able to still retain, those skills. We still need to be able to draft documents. We still need to be able to, research and do all of those things. And practicing arbitration is something that would help. It enhances our skills in doing things like that. Basically, my advice for young practitioners is to develop instead of to develop their legal knowledge instead of just basically focusing on AI. AI literacy is important, just as being tech savvy is important, but it's not the ultimate goal. So we need to double down on the fundamentals of arbitration. Like I said, legal reasoning, writing, advocacy, procedural knowledge. We really need to focus on that, but we still also need to remain curious about technology and learn how to use AI as a tool to enhance our practice.
Well, thank you for that. AI as a tool and not an end in this. Thank you, Annabelle. And Siobhan, what are your thoughts around this?
So I think I've kind of got 2 points to make on that. But the first one is that I think around the state of ADR and the way that AI is integrated into ADR going forward, I do think we're going to see more disputes about the use of AI itself. And potentially these could be, contractual disputes that we're all used to that happen to be about AI, or they could be disputes about the way that AI has been used in counterparty relationships outside the legal profession. And I don't think we've seen very much of that yet. And I do think that that is something that will start to filter through as we go on. But then the second point, I think, is something that's building on something that Annabelle said about accessibility of to AR tools in certain places, jurisdictions in the world. I mean, Annabelle was talking to Africa, but I can see how that would affect, Indian clients and clients in different parts of the world. So I think in a way, AI is a double-edged sword because it is a cost-saving tool and efficiencies if the cost of the AI tool is already absorbed by the large law firm. So it will be a question of whether or not there is a due process issue between, for example, if you had a very large corporate client making an arbitration claim against a smaller local, for the sake of argument, an African client, and one side had access to these AI tools and was able to process the documents and information much more efficiently, much more quickly, and the other side was not, didn't have access to tools that would enable it to do that. And I think the arbitrator's case management powers will really come into play in those sorts of scenarios. So I do think there'll be a sort of access to justice, fairness point that comes out of this.
That's right. Thank you so much for such an insightful discussion. And, that speaks to the confidentiality of the process, the powers of the parties, that's the party autonomy and the effect of having this generative AI. Thank you so much for that. And this brings us to another quite an interesting perspective. So when this data is shared onto the platforms of AI, and as we had earlier indicated that this affects, the access to information, and in an instance where a practitioner or a junior associate uploads particular information which is confidential to an open source generative AI, what are some of the arising issues that you will see at first? Because first of all, there could be copyright issues, that is on intellectual property of the material that is fed onto that platform. That is one. What are the issues that you see that are likely to arise? And Siobhan, you've indicated that there are likely to be disputes arising out of the use of this AI. What are the other maybe issues related that tribunals are likely to be flooded with in the near future? I'll start with you, Annabelle.
Yeah, thank you for that. I think also another major issue that we might perhaps be forgetting is data breach. There's several laws protecting data, confidentiality as well. So if we're uploading confidential documents, sensitive documents onto these open AI sites, open AI tools, then it's obviously going to, breach certain legal frameworks. So for example, in Kenya, I did a little research, and please tell me if this is wrong. But in Kenya, there are several cybersecurity laws. See, I can't find it anymore. But I I swear to you, I found two, but I can't remember where I wrote it down. But the point is those AI tools basically provide for um the use of safe, safe use of AI, safe use of technology. So if we upload sensitive information that bridges, this whatever law that is, it could even be just the arbitration rules, the UNCITRAL, LCRA, whatever that is. If it breaches that, then there is a problem. It is a cause for concern. It could also lead to upturning perhaps the reopening rather procedural stages of the arbitration. Um, Clients could also be ordered to pay costs. Certain documents or evidence could be excluded. So arbitral tribunals would draw adverse inferences. Basically, that's the point I'm trying to make. If you use AI tools that are against whatever cybersecurity laws you have in the seats of arbitration.
Interesting. Thank you. And as Siobhan gets ready to also put in, I thought you are right to say that we have some laws around the cyber security issues and the use of computer use and misuse. And currently, you might be aware, and I know my Kenyan friends are aware that we have the Artificial Intelligence Bill 2026 that is now in Parliament. So it's quite a current issue, and we must really play up to speed with this. Over to you, Siobhan.
Thank you, Mark. I think another really interesting risk that's coming out of these confidentiality points that we're making is legal advice privilege. I think there's been a very recent decision in one of the New York circuit courts. It's called Hepner, where the judge actually found that the defendant to that case had conversations with Claude, which is Anthropic's generative AI, open generative AI program. And the judge found that those conversations were not covered by legal advice privilege because Claude, they'd lost confidentiality by putting those kind of confidential matters into Claude, and B, because Claude is not a lawyer. So conversations with Claude could not attract legal advice privilege from the client. So I do think that is a very interesting and developing area of law that is arising out of recent changes in generative AI. I know there's no English authority on that point yet, but I wouldn't be surprised if the English courts have to deal with that issue quite soon. And I'm sure that the Kenyan courts will have a similar question before long.
Yes, thank you so much for highlighting those cases. And I would really request that panelists, you'll share the list of cases you've highlighted to our audience, maybe in form of an email follow-up to CAP, so that our members get to appreciate those authorities arising out of those different jurisdictions, and really to be up to date with what is happening. So, and at this point, Madam CEO, the CAP team, I had indicated I'm not able to see the chat button, and I don't know whether there are questions directed to our panelists before we give each of them a chance to give their closing remarks on this. In case there are questions, I would really appreciate that they are highlighted, and the audience is encouraged to ask questions about any matters they could be having, and they will need the panelists to highlight, since we have quite a quality panel session where you can be able to learn from different jurisdictions around the matters of AI and ADR. I see a comment by my good friend Lamek Nyamora. Thanks for the insight from the panelists, Mark. Apart from AI being a tool, I am curious to hear from the panelists about the potential of AI on the arbitrator's seat. Wow, good Is it the future? Are we going to see parties just feeding their issues on AI, and the AI tool makes a decision based on that? You meant an award based on the laws fed to its database. How do we brace ourselves as professionals for such realities? Thank you so much, Lamek. And I will invite our panelists. I know these are three-pronged question, which looks at the seat of the arbitration. What is the future? And how are we bracing ourselves for this? I will invite Annabelle to go first on this.
Well, I think this is a very important question, but it might be, I don't see AI replacing human arbitrators, if I got the question correctly. I think the person is trying to ask, is this sort of like a potential, is this the future? Um, Currently, at the moment, awards, not just even judgments from courts, needs human discretion and evaluation, for credibility. So we need to be able to access, humans need to be able to access witness testimony, weigh competing narratives, or even interpret commercial intention of parties. Now, if we were to have AI replace human arbitrators, this would completely be lost. Now, is this possible? Could this be possible? Perhaps in the nearest future or in the distant future, maybe it is possible that AI might be able to assist arbitrators and help them, review documents as is happening currently. But to replace them is, I would say, a long shot from now. I mean, I'm keen to know what Subin thinks, but I doubt that's going to happen in the nearest future.
Okay. Silvan, what do you think?
No, I agree. I think it's unlikely that there'll be a complete replacement of arbitrators, but I do think, well, there are a couple of points that come out of it. The first one is that there are certainly some jurisdictions which prescribe that the arbitrator has to be human. I think the French Civil Code prescribes that. I'm not sure of others, but I'm sure there are others. So, that's going to give rise to significant enforceability issues if an AI arbitrator made a decision and then you tried to enforce that award in France for sake of argument. But I think there's a very interesting case study coming out of the American Arbitration Association, which has just released its a limited use AI arbitrator tool, which I think is at the moment limited to so documents only construction disputes, because construction disputes, I guess, are a sector where there's quite a lot of similar formulaic documents that come out. I think that, well, obviously it's still, I don't think any awards have come out of it yet, but it was released in November 2025, and so we will see how that progresses. But it is something where the award is meant to be reviewed by a human arbitrator. So it will be interesting to see how that works and whether there's lots of uptake. I think it's consent-based at the moment. So, well, I don't see how it could be anything otherwise. But parties have to, even if they have an arbitration agreement, they have to separately consent to use the AI arbitrator. So I do think there'll be developments coming, but I don't think it will replace human arbitrators completely.
Wow, interesting perspective there. And Lamek, I think you
I
take
do.
notes. Yes, Annabelle.
Sorry. I just
Annabelle.
wanted to comment. I absolutely agree with Subhan, and like I said, it's a long shot away. However, I think it's also quite important that we talk about, or just highlight a little bit about some situations happening in some parts of the world, like China. China has something they call small courts or internet courts, and these courts basically use AI to automate, parts of judicial processes, things like case filing, evidence evaluation. They also draft judgments. So an example is I don't know if I'm pronouncing it correctly, but the Hanko's Internet Court, which was established in 2017. So this Internet Court has handled online disputes such as e-commerce or copyright issues. So it might happen eventually, but at the moment it's not as widespread, and certain jurisdictions like France, but they ban internet arbitrators, so to speak.
Okay. Thank you so much for that addition, Annabelle. And Lamek, as you might be aware, that in one of the cases from the High Court, they struck out an application that was AI generated. I hope you are aware that's from the Kenyan jurisdiction. And that speaks to, the relevance of human drafted references or even submissions. You might be keen to want to check that. We're having more questions flowing in, and I can see one from David Onsari, our chairman for the Young Members Group Kenyan branch, asking, and this goes to both our panelists, does AI improve access to justice in arbitration, or does it quietly widen inequality by giving the better funded party access to better tools, better prompts, and better verification capacity? What are your thoughts around this three-pronged question? Sioban.
So I agree, and this is something that I mentioned earlier. I do think there is a risk it will widen inequality. I think that's an issue that already exists in the practice of arbitration. So it's not new, something that's derived solely from AI's uptake, but I do think there is a risk that we need to mitigate as practitioners, that AI will certainly widen the gap between very well-funded parties and less well-funded parties.
Yes, interesting. Thank you. Annabelle, I know you had spoken to this, but we'll really like to pick your thoughts again.
Yeah, I completely agree with Sivan, and this is something that we talked about when we drafted the guideline. I think we called it inequality of arms. It might be found in section 2, but don't quote me on that. But but yes, it is something that would actually widen the gap. And when we did our research, some small and medium-sized law firms in London, and I'm sure it applies, across the board, they basically complained and said, well, these large law firms have access to these really good tools, and we can't afford these tools and all of that. So it is a problem that could happen. But we provided a somewhat theoretical solution, which is basically that if you're using any AI tool, either party, they must declare, to say that this is the AI tool that we're going to be using. And if there's some form of disparity, the tribunal or the arbitrator can come in and perhaps provide, a ruling or procedural order to say, well, this is how, you should use this, or perhaps find a solution to the problem. But I think disclosure is pretty important, and that would help to close the gap.
Yes, thank you so much, Annabelle. And as a follow-up to that, there is a very good question from Derek Asala that you might be keen on. They're asking Ms. Annabelle has stated that there is no allowance for an arbitrator to use AI to draft the award itself, even if they disclose such use of AI, that is in brackets, to draft the award. Are the guidelines, and you see you are an author in this particular document, are the guidelines just prescriptive in this respect, or can an award be set aside on the basis that an arbitrator has used an AI tool to draft his or her award?
Yes. So basically, what we talked about in the guideline, and I think it's part 4, we basically said that arbitrators have to declare, they need to tell parties this is the AI tool that we're going to use, and also tell them what that use is. Technically, when parties go to arbitrators, they want that human influence. They want a human arbitrator, right? And that's what they've agreed upon. So if an arbitrator decides to use an AI tool to draft, an award, and parties haven't agreed to that, it can be a ground to challenge the award. So I think that's very useful. Currently, that's typically not allowed, at least in some international context. I don't know about Kenya, but I doubt it's allowed in Kenya for arbitrators to use AI to draft their award. Is this going to happen in future? Maybe. I don't really know. But at the moment, it's not allowed. I think arbitrators can use AI for certain administrative tasks, but not to draft an award.
Thank you. And Sioban, what are your thoughts around that?
Well, I think that it's very similar to the problem that's been present in arbitration for a long time about the scope of work of a tribunal secretary. And maybe we're in a place where generative AI tools particularly will be replacing tribunal secretaries. So it's the same sorts of guardrails that we need on a tribunal secretary's work that might apply to the kind of work that the generative AI tool is permitted to undertake. Position taken in the CIARP guidelines and with what Annabelle has been describing, that it's really important that the parties consent to the types of tool and the tasks for which the arbitrator uses those tools, because otherwise we are in a position where there could be enforceability challenges. And also it's part of an arbitrator's general duties to ensure that their award is enforceable as far as possible. So there's potentially an argument that they are taking a risk if they were to use generative AI to draft their award, and they're not in compliance with their duties.
Wow, impressive. Thank you so much, Siobhan. And as we get ready for Tom Nyagare's question, he has indicated that he needs to share a perspective. I'll read Protais Yigiringiro. You will forgive me if I mention your name not correctly, kindly. Protais is asking, he will like to understand fully how we can balance the information provided by AI tools with authenticity and reality in this technological era. Like, he really wants to understand how to strike the balance between the information provided by AI and the authenticity and reality in this technological era. I think once you answer that, then we'll have Tom Nyagare share his perspective. Thank you. We'll start with you, Annabelle.
Thank you. Thank you for that question. I think AI, first and foremost, AI should be treated as a tool for assistance and not as a source of authority. When AI provides us with certain information, case law authorities or whatever the case might be, verification is essential. As we know, the doctrine of confidentiality is real in arbitration. So not all information are publicly available. So the algorithm would obviously not be fed with all the information perhaps that it needs. So once AI provides us with certain information, there is a need to verify this. And that's the starting point of research for any law students, talk more of like a legal representative. So it's important that we verify this. Also, professionals, we must maintain human judgment and critical thinking. We should be able to read through the documents and actually conceptualize, is this correct? Does this sound like machine language? Like, what is this? We need to read and be able to understand if this is relevant at all to the case at hand. Yeah, I think that might be it. There's always going to be AI hallucinations, bias in training data, and like I said, confidentiality issues. So my advice would be to verify the information you're getting and also to look at it and think and know if this is actually accurate.
Oh, thank you so much for that, Annabelle. Siobhan, what are your thoughts around that?
No, I agree. I don't have very much to add to that. That's very comprehensive. I think it's just really important to maintain the kind of your overview and your verification of the work that AI produces. But I think it's a good question because it's difficult sometimes when AI is developing at such speed to be able to catch up with it. And like I said earlier, it's very convincing. The answers it puts out are really high quality these days. So we just need to analyze it and assess whether it's correct.
Well, thank you. At least both our panelists agree that human judgment is quite key on this, and the use of original intelligence, alongside the AI tools. It's just a tool. And over to you, Tom Nyagare. I hope you have structured your question in a way that our panelists can be able to respond. Please proceed.
Thank you very much. I hope you can hear me.
Loud and clear.
Wonderful, Mark, and wonderful panelists for the insights that you're sharing. I want to share a perspective that is not mine first, then I'll share a perspective that is mine. The first perspective is from ChatGPT. I've asked ChatGPT a simple question: are you likely to replace arbitrators? It has told me I'm not likely to replace arbitrators. What I can do is to help them work faster, analyze information better, and handle complex materials more efficiently. The actual decision making, especially judgment, fairness, and credibility, still needs a human. Bottom line, I'm a tool for arbitrators, not a substitute for them. That's the perspective of ChatGPT on whether it has any intentions now or in the future to replace us as arbitrators. My perspective here, as arbitrators, let's stay on top of our game. What that means is that we don't delegate our role to the AI. We shouldn't. I mean, be deliberate on it. Do the right thing. Don't delegate your role as an arbitrator. But let us use the AI and other tools that you can be able to access to enhance our efficiency and effectiveness, because that is what distinguishes us from the machines. So my common and my strong perspective is that we can't shy away from it. We may find a way of guiding how we're using ChatGPT and other tools. I know some of us who happen to be arbitrators in the legal profession at the same time in technology and others may be interested in coming up with the systems that support arbitrators much better in terms of research, in terms of drafting, in terms of verification, and all of that. I foresee that we are going to have very specialized AI in the future in the legal and even in arbitration and dispute resolution. But at the end of the day, let's stay on top of our game. That's my perspective. The first one is the perspective of ChatGPT. Thank you very much, Mark, and everyone else.
Thank you so much, Mr. Tom Nyagare, for such insightful and fascinating perspective, especially two-pronged, looking at what ChatGPT, you just prompted it, but I will really invite our panelists to also chime in onto the perspective that Nyagare has raised, and then we'll proceed with the questions raised. There are two more questions I see as we come to the close of this webinar.
Yeah, I think I completely agree with him. I think AI should only be used, like I said, as an assistant as opposed to an arbitrator. There should be clear safeguards in place to guide arbitrators. We shouldn't completely forget that. I tell my students all the time, you have a brain. Don't forget to use it, okay? So we should also, in this context, remember that, yes, this AI tool is just here to assist us to, yes, make our life better, but not completely replace us. I mean, that would be really horrible. But yeah, that's just what I have to say.
Thank you, Annabelle. Siobhan, what do you think?
Yeah, I agree as well. I think we've just got to exercise our own judgment. I think it's interesting when in these kinds of webinars, people do ask ChatGPT or other tool the question that we're being asked, because they never give the same answer. It's always a variation on a theme. And, it's all about the prompt. So I think if you were to put in something that frames that question in a more negative way, you might get ChatGPT telling you that actually it will take over the world as an arbitrator.
Wow. Thank you for that. And I will take the questions that are on the chat. One from David Onsare, this is a follow-up question. He had asked an earlier question. Chairman is asking, what is more dangerous for arbitration right now? Overregulating AI too early and killing useful innovation, or underregulating it as we wait for the first serious due process challenge or set aside application to force the conversation? What are your thoughts, Siobhan, if you may?
Yeah, so I think this is an interesting point. I know the CIAB guidelines do state in their preamble that they could easily be redundant and might need to be replaced and updated quite regularly, I think. It's very difficult to regulate AI preemptively without knowing what the problems are. Regulatory authorities tend to be slower than the development of AI. I mean, as I said earlier, it's developing so fast at the moment that you just can't predict where it will be in a year, let alone 5 years. And then you have to balance that with innovation, but also with the fact that it's quite difficult for arbitrators. Arbitrators often get involved in an arbitration process after they've been appointed and everything, when something goes wrong. So when there's a challenge or a due process question, or they're asked to adjudicate on a procedural issue, and it might well be those are coming up regularly in arbitrations, but we just don't know because they're confidential behind closed doors. So this could already be happening. So I think it's going to be a combination of the two. I think it's quite likely that we will end up seeing a big set-aside application in the courts, which will force the conversation. But I'd be quite surprised if, I mean, certainly I wouldn't expect serious overregulation to really come into play too soon. I know lots of governments are putting together AI bills, but they're quite conservative. So my personal view is that it will be once the issue arises in the courts.
Oh, thank you so much, Annabelle.
Yeah, I think also just talking about like updating the guideline, talks are already on the way. You didn't hear that from me, but talks are already on the way. And like I said, AI is moving at such speed, and there is a need to put some form of regulation on it. There should be clear safeguards, like I already mentioned. If not, it's going to raise a lot of due process concerns for the parties. So it's important that it's regulated. Overregulation could also be a killer. Just like Sipan have said, we shouldn't. And currently, I think that we're trying to sort of step lightly, if I want to use the word, on regulating and over-regulating AI. So certainly, open AI models would cause a lot of issues, especially with sensitive information. But then we also have closed AI models that are, licensed and still regulated, but still do the work.
Well, interesting perspective there. Thank you so much. And I note the comment from Tom Nyagari highlighting that the bottom line is that AI indicated, actually ChatGPT indicated that I'm a tool for arbitrators, not a substitute for them. Wow, impressive. There is a question which gives us another perspective from Samatar Abdi. They're asking, how can arbitrators who use AI mitigate risks of data leaks or unintended training on sensitive arbitration material? I think we talked to this, but I'd like again to take your thoughts on this. That how can arbitrators who use AI mitigate risks of data leaks or unintended training on sensitive arbitration materials? Quite a current matter. Yes, Annabelle.
Yeah, I mean, I just have 2 points in this. I think first and foremost, you need to vet as an arbitrator or a legal practitioner using AI. You need to vet the AI tools that you're using. I think a key takeaway here should be do not upload sensitive information to open AI tools. That can be catastrophic. Also, you need to also perhaps look at the legal framework in your jurisdiction on the use of AI and find out whether or not if you're using this AI module, you're breaching the law. Because what we don't want to happen is, for example, with arbitrators having your awards upturned or challenged or whatever. So you have to make sure that you're not breaking any laws in using certain types of AI modules.
Thank you. Thank you. Siobhan, will you want to take that on?
Sure. I think it's, as Annabelle said, it's really a question of maintaining your confidentiality by using closed systems is really the important one. I guess you could, deploy reductions if you needed to use an open system in a more limited way, but I'd be quite wary of doing that. I think you would want to be really sure that you're anonymizing the data that you're putting in, and you're not kind of, there are steps you can take at the beginning to avoid confidentiality issues such as anonymizing data, and I think we should all be doing that.
Wow, interesting. And I think that brings us to, we have one question from Bridget Wanza, and I think this will be our last question from the audience in case another one doesn't shoot up, but we'll have this in the meantime as the last question. Then we'll proceed to our panelists making their their final remarks. Then I will make a closure and hand it over to Madam CEO. So we'll take this last question from Bridget. I'm curious as to whether there is a risk of a convergence of outcomes that prioritize consistency over contextual justice when AI is used in arbitration. A mention has been made of the risk being low as the prompts employed differ from user to user. Like, what are your thoughts around this?
I'm not quite
Bridget,
I'm not quite
yeah,
sure what the person is asking, but I think ultimately we should be able to exercise independent judgment. Like Saban has said, sometimes you put certain things in ChatGPT or something, and it provides you with a completely different information to somebody else. So if that is the case, you should be able to really think, and critical thinking is an important, skill to have. So you need to be able to vet the documents, read the documents, and ultimately apply critical thinking to make sure that what you're being given is actually the correct information.
yes, Yoban, you want to?
Exactly. I mean, large language models are stochastic, so they will produce a different answer and an unpredictable answer based on the same prompt, the same information going in every time. So it can be very difficult to, I think at this stage, we can't rely on open AI models or even closed AI models to take over our judgment and our functions as practitioners and arbitrators. It's just not there yet. But you never know. It's developing at pace. So we could be in a position where that really is a risk in a few years' time.
Well, thank you so much. And Bridget, I hope you take note of that with the LLMs, the large language. Thank you for acknowledging that. Thumbs up. Okay, nice. And I see our CIAB Kenya have shared the CIAB guidelines on the use of AI. This will really interest the members and the practitioners to acquaint ourselves with the same. And at this point, if you may allow me, I will invite, at least we've had quite an active audience asking questions and quite informative, I must say. But at this point in time, I think we've handled much, and I will invite, our panelists, starting with Annabelle, to probably give their upshots, their closing remarks.
Well, I want to start by saying thank you very much for inviting me. I think it's been a very insightful discussion on the use of AI. I think if anything, AI is growing fast. It's we can't even talk about it without something else popping up. It's growing at so much pace. So we have to make sure that we're using AI ethically. That should be at the forefront of our mind, that we're using AI ethically and responsibly, especially for international arbitration. We're disclosing the use of AI when we need to disclose it to parties, especially if there's a risk of high AI use and it's going to prejudice the other party. So this should be disclosed. Additionally, we should also make sure that we put clear safeguards in place. We shouldn't be uploading sensitive information, whether to open or closed AI modules, really. It's important that, like Suban have said, some of those really sensitive information should be redacted. Also, due process concern is a thing. Accessibility to AI, especially the disparity between really large law firms and the small law firms, is also something we've talked about today. So it's something to keep in mind as well. Lastly, just is hopefully not going to replace. Hopefully, AI is not going to replace us anytime soon, but we never know.
And it's got some great things that we can build on. So we just need to make sure that we're maintaining our independent judgment and using it for particular tasks rather than seeking to apply it to the entirety of a dispute. and even using it for specific things and not trying to make judgments based solely on complexity or procedural efficiencies. It's got to be for where it's useful, and it's not useful for everything. And I guess the sort of underlining point of the session has been, got to verify everything it produces. We've got to verify it. And then lastly, I just want to say thank you very much for having me as well, and thank you for your insights and excellent moderation. It's been a pleasure.
Thank you so much, Suban. And I think with that, we come to the end of this. We covered all the questions, and thank you so much for such an incredibly rich discussion. Maybe a few key takeaways from this particular webinar is that, we've established that AI is not a futuristic concept, but rather a present-day tool that we must engage with. It's not here to replace us, but rather a tool to enable us in handling the disputes in the arbitration. And we've also added that the responsible integration, guided by transparency, accountability, and professional judgment is the only path to effective use in this. And the new CIAB guidelines are a critical resource in this regard. These have been shared in the chat, and please, I invite all the members of the audience to download and have a look at it. We have learned also that while the tools may be global, the context is quite local, and the practical strategies as to the ethical standards, the practice procedures may differ from one place to another, but the underlying ethical principles remain the same, and those are the guiding principles. And finally, we've been reminded that AI takes over more of the mechanical tasks and the human elements of our profession. That is, the advocacy, the judgment, the empathy, and strategic thinking will only increase in value. Thank you so much for our incredible panelists, Yoban, Abraham, and Annabelle Onyefulu. You didn't tell me whether that's the pronunciation.
It's actually correct, Onyefulu, yeah.
Oh, thank you so much, Annabelle, and for sharing your time and expertise so generously to our audience. The depth of your insights has been quite outstanding, I must say. Thank you so much, the CIAB Kenya branch, particularly the CEO, Evelyn Kimani, the president of and the chairman of CIAB Kenya, Professor Wayne Mutuma, and the research team, Prudence Jakusahau, for organizing such a timely and quite an important event. And back at home in Kenya, you are aware of the Artificial Intelligence Bill 2026. This was lodged in Parliament, and I invite all of us, because we are practitioners, this is a current matter. Let's look at it, let's interact with the documents, let's raise questions, let's give suggestions where necessary. And most importantly, thank you so much to all of you, our audience, for logging in and engaging, with these critical questions, quite informative, and you've thus brought this discussion this far. Please do stay connected with the CIAB Kenya branch for future events. And from me, Marco Rocco, goodbye and enjoy the rest of your day.